Hello, everybody. Good morning, ladies and gentlemen. My name is Stefan Moritz. I'm the Managing Director of European Entrepreneurs, a European Confederation of National SME Associations in the European Union, but also beyond. We have also members from outside the European Union. And we represent the voice of the voluntarily associated SMEs, so no obligatory membership, organizations like chambers of commerce or chambers with crafts chambers. And we represent in this sense 2.1 million enterprises that have voluntarily joined our national member organizations or our pan-European members. Also, we one of our European members, pan-European members, is the Association of the European Lawyers called Eurojuris. Now the following speaker, Mr. David Emmerich, is a member of Eurojuris, and he will represent in this way also our member in Europe in the field of law firms and lawyers that are near to small, medium-sized enterprises. Our confederation has been offered by the World Intellectual Property Office, WIPO, the opportunity to learn about their activity in the field of arbitration, dispute resolution, and mediation for intellectual property and technology disputes. And we found that a very interesting topic because our confederation, of course, bears a large number of European companies that are active in the field of exports, especially, but globally active, offering their services and products not only as products that are shipped, but also online. And of course, we are in the position that we need to help our members to learn how they could, in case, defend their intellectual property if it comes to a dispute, to a misuse, to a supposed misuse or whatever, but let's say a clash between interests from companies from different countries. That can be also inside the same European Union, but of course also outside. And that's why we think it is absolutely necessary to learn about these opportunities, this resolution way to arbitrate or mediate these conflicts before you go to a full court. More in details and how to what are the opportunities here and what is on the table or what is at stake will be explained by the speakers. The first one to open, as I said, is Mr. David Emmerich. He's a member of Busekist law firm in Germany, Düsseldorf, and he's now in this moment in Brazil, connected with us in the middle of the night. Thank you very much, Mr. Emmerich. Good morning. And the second speaker is Chiara Accornero of the World Intellectual Property Office with a seat in Geneva. She had not that early to stand up today. And she will explain us the work and the service of the Alternative Dispute Resolution Office of WIPO. And then Mrs. Kathleen Paisley of Ambos Lawyers will tell us a little bit about her experience as an arbitrator and mediator in such kind of resolution processes. And we will understand maybe better how it feels, how it works, where the challenges are, and so on and so forth. I would like to ask you, please, to let your microphones switched off as long as you're not speaking. At the end, let's say after the three speakers, we will have 20 minutes for Q&A, so plenty of time to ask all questions that you can bring forward. We are absolutely open to that, and definitely also you are now, thanks to the fact that you are registered to this platform, SME-to-be, you are in the position from here to the next month and year to connect to the other members and participants to this workshop and to meet them directly in case you think that might be interesting for your business to develop your activity, and also meet them live, let's say in video call inside the same platform. So thank you very much for being here, and Mr. Emmerich, the floor is yours.
Well, first of all, thanks a lot for the invitation. I'm very glad to have the opportunity to say a few words on the international protection of intellectual property rights, and especially the problems that arise when trying to protect intellectual property on an international level. Regarding my person, as Mr. Moritz already said, I'm a lawyer at Busekes Winter & Partner in Düsseldorf. I work for like 10 years now in the field of intellectual property law, principal mainly trademark law. And as he said already, I'm currently in Brazil. That's one of my international focuses, where I work with intellectual property on an international level. I prepared a small protection. So just a minute, I hope it's working. Yes, perfect. Well, when it comes to international protection of intellectual property rights, there are mainly three principal topics. It's obtaining international property rights, the enforcement of intellectual property rights, and contractual relationships, meaning licensing, franchising, transfer of intellectual property, and research contracts. Obtaining intellectual property rights on an international level means that if I want to have a protection for my trademark, let's say in Australia, I need to obtain an intellectual property right protection, especially in Australia. For example, I have to register my trademark in Australia. Enforcement means when I detect an infringement of my intellectual property rights, I have to make the infringer stop, or either extrajudicially or judicially. And contractual relationships means that if I want to exploit my intellectual property rights on an international level by licensing or franchising, I have to conclude contracts on an international level with contractual partners from another states. So first of all, why is it a problem to protect international intellectual property rights on an international level? The problem arises principally because of a conflict between the territoriality principle and globalization. The territoriality principle means basically that the intellectual property rights are protected only in the state that granted the intellectual property rights. For example, if I have a trademark in France, this trademark is only protected in the territory of France and not outside France. So when a French company decides to export its products to, let's say, Australia, it does not have necessarily a protection for its trademark in Australia too. So there arises a conflict between the protection, the scope of the protection of the intellectual property right, and the action of a company doing business globally. So the company has to seek for protection in every state internationally where it decides to do business in. So if it wants protection in Australia or India, it has to seek for protection in Australia and India separately. There are now, let's say, international intellectual property rights. Of course, there are international treaties, so it makes those treaties makes it easier to obtain an international protection of intellectual property rights. For example, via WIPO, it's easier for a French company to register a trademark in Australia or India. But nonetheless, the problem stays that I always have to seek protection in every state separately for my intellectual property assets. I cannot rely only on my home intellectual property rights. I have always to see that all the countries I'm interested in doing business in, I have to focus on those countries and try to get a protection in those countries. Otherwise, my intellectual property rights are not protected in those countries, although I am doing business there. There are some exceptions with copyright law. In copyright law, there are some automatic protections, but let's say in general, it's with trademark, with patents, with designs, or trade secrets even, we always have this problem of a limited scope of the protection on the one hand, and globalization, global acting of the businesses on the other hand. So there arises this conflict. One has always to focus on the problem that maybe even acting outside the European Union, outside Africa, outside South America, not necessarily do you have a intellectual property right in those countries. So the second problem is the enforcement of those intellectual property rights I got in other states, and I joined enforcement and contractual relationships because the problems are very, very similar. In both cases, when I detect an infringement or when my contractual partner does not comply with the obligation of the contract I concluded with him. For example, if I have a franchise partner in Brazil and he does not comply with all the obligations that are in the contract, I have to seek to extrajudicially or judicially to try to enforce my intellectual property rights. And this can be complicated on a national basis, but it gets very, very complicated on an international scale. Why is this a problem? Well, first of all, if I act in another country or in another continent even, first of all, I have to deal with unknown foreign law. As let's say a Dutch company, I don't know what the law of Brazil are or what the laws of Japan are. So it makes it very complicated for me to know exactly how things work in different in other countries where I'm doing business. And it's getting even more complicated if I'm acting in not only in one country outside my home country, but in several different countries. So I have to deal with several different jurisdictions. Let's say I registered my trademark in Brazil, Japan, India, and Australia. But now I have 4 different jurisdictions in which I have to seek or in which I have to try to enforce my intellectual property rights. So I have to deal with law of Brazil, law of Japan, the law of India, and law of Australia, which especially for small or mid-sized companies can be very, very complicated. Further problem is the predictability. If I have several different jurisdictions with different laws, it's very difficult for me to predict how those courts will decide. I have no idea how they will decide in Brazil, how they will decide in Australia or in Japan. So it's very hard to decide, for example, if one enforces its intellectual property rights based on this unpredictability of the court decision of different jurisdictions. And a fourth problem is that the decisions of the court in those other states are limited in their scope. So, for example, if I registered my trademark in India and in Australia, and I detect an infringement in both countries, I get a favorable decision in India, for example. I cannot stop the infringer in Australia based on a decision I got in India. So every decision of the court is basically limited to the state of that court. So that's a problem. That's like I said in the beginning, the protection is only national due to the territorial principle, and this also kind of is valid for the enforcement of the intellectual property rights. So I always have this problem. I'm acting internationally, but my intellectual property rights are kind of linked always to one country only. Further problems that may arise, I say may arise because the problems I explained here always arise independent of the or irrespective of the country I'm trying to enforce my intellectual property rights. But there may be some problems that arise in some countries, not all of the countries. For example, in some states, court proceedings are very slow. So maybe I'm trying to protect my intellectual property rights in several countries. And in one country, it takes 1 year, for example, to get a court decision. There may be another country where it takes 3 years, or I don't even know when the court will decide. It gets even more complicated if there are several instances. So I can get in states, I can take there for 5 or 10 years trying to enforce my intellectual property rights. And this can be a problem because it's kind of worthless if I can't enforce my intellectual property right. And if infringers know that, they are not trying, they do not stop infringing my international property rights. So another huge problem can arise with respect to technical intellectual property rights, patents or trade secrets or even trademarks in some cases, which is confidentiality. Not all countries give a confidentiality in court proceedings when I enforce my international protection of intellectual property rights. For example, in European countries, there are normally proceedings, there are means I can seek to protect my trade secrets or secret information during court proceedings, but not all countries have such a guarantee. So this can be a problem. For example, if I have a licensing contract and in court proceedings, I have to deal with sales numbers, for example, or other sensitive information. This maybe can impede that someone goes to court because he fears that everyone has access to his confidential information within this proceedings of international of IPRs. So some states do guarantee a confidentiality, but not all of the states. And this all I have to verify which states do, which states do not. So that can be very complicated. And a final problem that can arise, I'm not saying that it arises, but it's neutrality. So, or even the feeling of lack of neutrality. For example, I maybe in another state, I got the problem that the courts might favor a local infringer over a foreign owner of IPRs. So there are a lot of reasons why it is very, very complicated to enforce intellectual property rights in courts on an international level. So basically summarizing, first of all, it's very important to verify in which states outside my home country I am doing business. And if I'm doing business in states outside my home country, it's very important to protect trademarks, my patents, my designs, my copyrights for software especially, and my trade secrets only also. So there's always the first step, verify in which states I am acting, and do I have protection? If not, I have to seek special protection in every state. The second problem is if I detect infringement, or if I find out that a contract partner is not complying with my contract, with his obligations of the contract I concluded with him, I have to seek protection by enforcing my intellectual property rights. And as I said, this is far more complicated than registering a intellectual property right in another state. So how to solve these problems will be subject of my colleagues, which is their expertise, and they will explain which alternatives I have for national court proceedings, which might better help me on an international level. Thank you very much.
Yeah, thank you, Mr. Emmerich. I think that opens up very clearly what is the situation a company, especially a small medium-sized enterprise, could find itself in. And now I think with these challenges, maybe an alternative dispute resolutions, a mediation could be a good way to cope with these problems or challenges. And that's why we would like to hear now the proposal that the World Intellectual Property Office has for us. And please, Mrs. Chiara Accornero.
Thank you very much, Mr. Moritz. Thank you very much, Mr. Emmerich. Good morning, good afternoon, good evening, everyone. So my name is Chiara Cornero. I work at the World Intellectual Property Organization. I'm a legal officer at the office in Geneva, although the previous 3 years I spent at the office in Singapore. And perhaps before we really go into the mediation arbitration services that WIPO offers, I just wanted to take a step back, because probably not all of you are really familiar with WIPO, what WIPO does, what WIPO is. So WIPO, the World Intellectual Property Organization, is an agency of the United Nations. And in particular, it's a specialized agency in intellectual property and technology. And that's also our office there. So I think you can all see my slides. So what do we do at WIPO? We try to help businesses protect their intellectual property. And we do so by offering a range of services. So for example, some of them facilitate the international registrations of designs, patents, trademarks. And this is what Mr. Emmerich was mentioning before. The struggle of having to go and register your IP rights, your design, your mark, your patents in all the countries that you want to have protection. We try to facilitate that with some procedures that facilitate the international registration in multiple countries of your intellectual property. So something else that we do, we also provide arbitration and mediation services. And these are ways of resolving potential disputes that may arise, which are alternatives to court litigation. And here, the idea is really to provide parties, and by parties, I mean companies, including SMEs, startups, universities, individuals, whoever has an intellectual property right, to help them resolve their dispute as quickly and in the most also cost-effective way as possible, so they can get on with the dispute and go back to their business. So we really try to limit the impact that disputes have. So at the WIPO Center, where I work, we specialize in intellectual property and technology disputes. So for example, what we do, we have a number of experts, mediators, arbitrators. Kathleen Paisley, who is going to be the next speaker, is also one of our mediators and arbitrators. And all these experts are specialized in intellectual property and technology, so they know very well the context and what we're talking about, and they can be appointed in our cases as mediators and arbitrators. So we have this specific expertise. Then, and this is also what Ms. Emmerich was saying, the neutrality, the perceived neutrality of having to go to a specific country's jurisdiction. One of the advantages of WIPO is that because we're part of the United Nations, we have no connection, no link to any jurisdiction, to any court, to any legal system. So we can really offer neutrality. And this is something which is really important if you're ever involved in an international dispute. So if you are involved in a dispute with a party from another country. So we offer this neutrality. And also our fees are not for profit, in the sense that we try to keep these procedures as cost effective as possible. And this is because we see in some of our cases, multi-million dollar claims, but also we see much smaller cases involving, for example, SMEs, startups, even individuals such as inventors, designers. So we always try to tailor and adapt the procedure to the parties, also in terms of cost. In particular, for SMEs, starting this year, we also have some specific reductions on our fees. So really, time and cost are some of the issues we really focus on. And then Mr. Emmerich already raised some of these points, but I wanted to share with you what can be some of the advantages of using mediation and arbitration whenever you're involved in an IP or technology dispute. So time and cost is one. Mediation and arbitration, in particular mediation, are much cheaper and also faster than court litigation. And in particular time, whenever we're dealing with intellectual property, technology disputes, time is very often of the essence. Because if then with a court, it takes you 1 year, if you're lucky, or even longer to get a decision. After 3 years, it may be that the technology is already updated. So really, time is really of the essence whenever you're involved in an IP or technology dispute. Then very often these disputes are very often international, or they have an international dimension, they have an international element, because, for example, the other party is based in another country, so you may have to go and litigate your IP right in that country, and that creates complications. Also, decisions that may not be consistent. What mediation and arbitration do, they actually offer a single procedure that you can then use and enforce the result of this procedure in all the countries which are involved, with also a saving in terms of time and cost. Confidentiality is another huge advantage of mediation and arbitration. Mediation and arbitration are fully confidential procedures, which is not the case in court litigation. And this can be relevant, for example, when you have confidential information at stake, for example, trade secrets, but also in terms of reputation. So mediation and arbitration really allow you to keep the procedure private and confidential. And then a very important aspect for IP technology disputes is also the expertise, because IP disputes can very often be specific, maybe they relate to patents or very specific matters, and not all courts may have that expertise. In mediation, in arbitration, what parties can do, they can select their mediator, their arbitrator. So they can also choose someone with some specific expertise of the intellectual property and the subject matter. And on that, I was mentioning before that we have this database of experts in intellectual property that can be available in our case as mediators and arbitrators. And the last point I wanted to mention is, and this goes for mediation in particular, because mediation is a very collaborative procedure where the purpose, the aim is to settle, to find an amicable solution. It also helps parties, if they had a contractual relationship, to maintain that contractual relationship. And very often in intellectual property, think, for example, of research and development, there are this long-standing collaboration, which is important for the parties to keep. So very briefly, because probably some of you are already familiar with the differences between mediation and arbitration, I just wanted to spot some very basic differences here between the two procedures, because they are different procedures. They can also be combined together. Mediation is a particularly informal procedure when you have a third party, so the mediator, and the mediator here is not a judge. The mediator is not a judge, is not an arbitrator. The mediator is not going to make a decision, it's not going to impose any decision on the parties. The mediator is going to help the parties finding a common solution. So it's not going to impose a decision, it's going to help parties find their own decision. And what's really interesting is that very often this settlement, this solution is not necessarily based on the parties' legal rights and obligations on the law. Usually it's based on the party's business interests. So what the mediator does, it tries to meet the party's interests and find a solution to their dispute. But at the end of the day, it is both parties that need to accept and find the solution. So the mediator cannot impose anything. And in this sense, mediation is very particular also because the parties have full control of the procedure, of course, of the outcome of the solution, but also of the process. Because if at any point in time they feel that the mediation is not leading to a common solution, it's not really working, and they want to start litigation, co-litigation, or arbitration instead, they can end the mediation at any time. So very often mediation is also used, and we see that a lot in our experience. We actually think it's a very good idea to have a first mediation phase before then a co-litigation or arbitration phase. Arbitration is in a way a bit more similar to court litigation in the sense that here you have an arbitrator or a panel of arbitrators which are going to impose a decision on the parties. Decision which is going to be based on the parties' legal rights and obligation, and the parties will be bound by this decision. One of the main advantages of arbitration is that it's enforceable internationally. There is a convention, the New York Convention, which has been adopted by really most countries nowadays, that allows you to take the arbitral award, which is a decision of the arbitrators, and enforce it also internationally in other countries. So that's really, I would say, probably one of the main advantages of arbitration. So this is just to give you an idea of how the two procedures work. Now, what do we do at the center? How can we help? First of all, even before there is a dispute, we can also help parties whenever they're drafting a contract, an agreement, include a mediation clause, an arbitration clause in the contract. We have other clauses also on our website, but you can also directly get in touch with us, and we can assist, we can help you draft these agreements. Also, if you're involved in a dispute, we can give you procedural advice, so we can see which procedure may be most appropriate to resolve your dispute. And then once there is a case, a mediation or arbitration with us, we administer the case. So basically, we facilitate case communications, we enforce timelines, we help the parties finding the mediator, the arbitrator. We basically make sure that the case is on track. We always have this focus on time and cost-efficient solutions. We also have, and this is something which I think It's very important because it's also another way of containing time and costs. We have online tools, so video conferencing tools, for example, that can be used in our cases completely free of charge. They have been used massively the last years, and we had a very positive experience with those. So it's an option that we really encourage parties to consider. And I was mentioning that we help the parties finding their mediator, their arbitrator. I think this is a very crucial point, especially for IP disputes, technology disputes that, as I was saying, are very specific. So finding the right expert for that dispute is really crucial. What we do is we have this database of really more than 2,000 experts in all fields of intellectual property, in all jurisdictions that are available to act as mediators and arbitrators. But at the same time, we don't just select someone, we actually work with the parties. We try to involve the parties as much as possible in the selection process. So we ask the parties if they have any specific qualifications, requirements they would like the mediator or arbitrator to have. And then we propose some candidates to the parties. So we really try to get the parties as involved as possible in this process. Online tools, this is something which is available. Parties do not need to use them. Of course, they can meet in person if they wish. And we can also help finding meeting rooms, arbitration facilities. But we really would encourage considering these online options because they really they are offered free of charge to start with, and in our experience in the last couple of years, they resulted to be very, very effective. It's also sometimes much easier to schedule a meeting, a mediation meeting, even arbitration hearings online, and this really also expedites the proceedings a little bit. Now, for SMEs in particular, we also have some reductions. I mentioned that before. We also provide some complimentary, so completely for free, procedural assistance in the sense that we can help you draft these clauses that you need to start a mediation, to start an arbitration. And also there are some reductions on our mediation and arbitration fees. And this is really also to make mediation as accessible as possible also for smaller enterprises. So this is to give you an idea of the cases that we see. Kathleen is going to tell you more from her perspective as mediator. But as you can see, we have mostly intellectual property cases, patents being still the majority. Trademarks and IT software cases are also a big part of our caseload. What I really wanted to focus on is really the settlement rate, because it really shows that these procedures, they work. In mediation, the settlement rate is 70%. It means that in 7 cases out of 10, the parties manage to find a solution. And this solution is really a common solution between the two parties. And in fact, in the last year, where online tools were mostly used, we've seen an increase of the settlement rate, which is now close to 80%. It's also something that changed, which I thought is quite interesting. We call it the case source. So half of our cases are contractual, so they're based on a contract and there was a dispute resolution, but the other half is non-contractual cases. So cases where there is no contract, no previous agreement between the parties. So the typical case is that of infringement. So someone that sees its IP rights, its patents, his mark, his design being infringed, maybe by a party that they don't even know. So to also help parties deal with such a situation and to facilitate even the access to mediation even more, we also give the parties the opportunity, the possibility of filing of requesting mediation unilaterally. So this is very simple. It's a one-page document that a party that finds, for example, an infringer can submit to us requesting the mediation. And then what happens is that it's us, the WIPO Center, getting in touch with the other party. So then we help both parties considering the WIPO mediation option. So this is really a way to help parties and one party unilaterally, especially where there has been no contact with the other one, to start the mediation process. And perhaps just to conclude, I wanted to give you a real example of a case that we have administered. Of course, it's anonymized since all cases are confidential, but to give you a more practical idea of how a case runs. So this was a mediation case between two startups, one from Asia and one from the United States. These two, it's in the area of IT, mobile applications. These two parties, they had an agreement. It was a licensing agreement for some mobile phone applications. After a few years, there was a dispute between the parties on whether a certain use of the software was authorized or not, and whether certain royalties would need to be paid. So in the contract, there was already a clause saying that in case of dispute, parties will try to resolve it through mediation, and if it doesn't work, arbitration. So here the parties started a mediation. They came to us. They requested a mediator with particular expertise in technology cases. So we provided the parties with some candidates, and the parties agreed on one mediator. So here, what happened is that the parties were based in different jurisdictions in Asia and in the US. They also had some cost constraints. So they actually suggested, instead of arranging travel, which was not convenient for them, to have the mediation held not even online, but actually only by a telephone. The mediator agreed. So the whole mediation process, which is normally a few meetings with the parties alone and then some joint meetings with both parties together, it took place entirely by telephone. This was provided by WIPO, so completely free of charge. And then within 3 months, so we're not even talking about a year, but or 3 years, but 3 months, the parties found a solution, which also allowed the parties to continue the collaboration. And this is really also the bottom line, is that mediation arbitration are very effective in resolving disputes, but at the same time, in particular mediation, sometimes they can also go beyond the resolution of the dispute. So really allowing parties to continue the collaboration that they had before. So really, it's an option to keep in mind. And I think Kathleen will have plenty of these examples. So I will give the floor to the next speaker.
Yeah, thank you very much, Mrs. Acornero. WIPO is here offering really a big, interesting range of services and also, let's say, showing us the way how to start from the license agreements or to put inside the process already the possibility of arbitration through the WIPO services. Now, I think we heard already the first cases. We would like to maybe understand a little bit better how such an arbitration can work, and let's say to hear a personal experience from an arbitrator, and that would be Mrs. Kathleen Paisley of Ambos Lawyers from Belgium. Good morning, Mrs. Paisley. Would you please explain us a little bit how such a procedure could work and what the parties should take care of? Thank you.
Sure. It's a delight to be here. I'm Kathleen Paisley. I act as both an arbitrator and mediator of technology and life sciences disputes, others as well, but primarily technology and life sciences. I've worked with the WIPO since the very, very, very first meeting. So I am a big fan. But I also have a background that is not solely as a dispute resolver. I have acted at a law firm for technology and life sciences clients building their agreements, many of which include WIPO arbitration mediation clauses. In addition to that, I'm currently in-house at a publicly traded company, but one that often feels like a startup in Belgium. So I see these things from all angles. In addition, the arbitrator is really the judge of these disputes, the one, so if you have an arbitrator, the arbitrator decides. Mediation's a different skill. Mediation is really facilitated settlement. And different mediators look at mediation in very different ways. So I think obviously an arbitrator is important. An arbitrator is going to decide your case. You want a smart arbitrator, you want someone with knowledge of the particular area of the dispute. Sometimes not too much knowledge, because then perhaps they're biased one way or the other indirectly, but you want someone who knows what the area is about. With a mediator, you're looking for someone who is able to get the parties to agree to a solution that makes sense for them. So I tell folks that really the kind of people who make good mediators often were never litigators. They were never arbitration counsel. They were deal counsel. They were the ones who made the contracts, the ones who got to yes. Those are the kind of people who tend to, in my view, be the best mediators. So I wanted to take a little bit of a step back and go back to some of the things that Chiara said, because I think it's very important to think about how one gets there. There's the first step as in-house counsel for a SME is to think about what's going to be in your dispute resolution clause for your agreements. I always, and it's not just Chiara's on the phone, suggest as the first step, a WIPO mediation followed by expedited arbitration, even when it might be a $1 billion license. Expedited arbitration after mediation. Why? Because there's no case that cannot be done in 9 months, which is what happens with expedited arbitration. Now that's when I'm the right holder. If I'm on the other side, I got a different position, but if I'm the right holder, I want it to go very fast. So I think you really need to think as in-house counsel, first thing is that, or whatever you do at the SME, maybe you don't have a lawyer, but when you look at your contracts, really think about what the dispute resolution clause is going to say. And often, particularly with SMEs on both sides, the other side really doesn't care. So you can get what you want if you know how to make the argument, which Chiara can help you with, or I can. Give me a call. And one of the arguments for mediation is that, for example, myself, I have never mediated a case as counsel or mediator that did not settle as a result of the mediation. Never. And now that's because I don't only count the cases that settle in the room. I also count the cases that settle a week later, a month later, 6 months later. I see I have a question from Peter. Did you want to ask it now or wait till the end of the presentation? I'm happy with either.
I would advise to wait maybe with all questions after your presentation. I think maybe you might already answer something. Mr. Atta, please, in 10 minutes, we will have the time for the Q&A. Thank you very much.
Great. So when I am acting as a mediator and I get the case, the first thing that I'm thinking about is, how did we get here? And what do these parties really need from each other, if anything? The hardest cases to settle are divorces. If there's a potential for reconciliation, like Chiara said, there's some there. Those cases are relatively easier to settle. If it's just a question of who gets the house and the visitation rights with the pets, those are more difficult because the sides don't have equal interests. And then people get all legal. And the one thing to realize is different mediators have a very, very different view of their role. So if you decide to put a mediation clause in your agreement, the first thing that will happen is someone like me will send you an email and say, I've been appointed as your mediator. Let's have a call. And then we'll have a call and we'll talk about what the next steps are. In some mediations, that means producing a mediation statement, where each side says these are our positions. Sometimes that's not even necessary. So it really depends on the case. But my view is that my job is to facilitate settlement. So I will think about the legal merits. I will think about what the parties' potential future collaboration might look like. I'll think about all that stuff. Other people would say that everything legal is off the table because that is what a conciliator does, or that's what an arbitrator does. So the choice of mediator is essential. What do they consider their role to be? What is their style? Will the other side like them? But that's something that the WIPO can help you with. So the first thing I would say is your job as in-house counsel is not to have a mediation. Hopefully you've been able to settle beforehand, particularly if it's with a contracting partner. If it's not, if someone sued you, then, but before you sue them, you might want to think about having a mediation as well. But once you come to see me as a mediator, what I will do is I will set up a call with you and your colleagues on the other side and try and work through together. The first thing you mediate is the procedure. You want both sides to be comfortable with the procedure. The WIPO has an excellent procedure set out in its rules, but sometimes that procedure isn't exactly suited for purpose for the case, in which case you might have a slightly different procedure. But often it will involve some form of writing for the mediator. Not always, but often. Then the next step is to have a meeting. Chiara was talking about the benefits of virtualization for mediation. When we all went virtual 2 years ago or so now, the general view was it would be okay for arbitration, witness testimony, a little difficult, but it would be okay for arbitration, but for mediation, it was going to be more difficult. I think that actually that has proved to be wrong. I find online mediation to be as effective, sometimes more effective than in-person mediation. Why would I say that? Well, first thing is you have more time, which is a good and bad thing. One of the ways that you get to settlement as a mediator is everybody's looking at their watch and their planes are going at 6 o'clock and they want to reach a settlement. So that you don't have. You don't have that artificially imposed deadline. But you do have more time, and that allows the parties to develop their positions in a way that they're each comfortable with. And let's face it, sometimes a litigation isn't about the logical merits of the case. It's emotional. People are angry and they want to vent. And giving them more time allows them to vent a bit, which is a good thing. So I think that virtualization has really helped mediation. And another way I would like to add is particularly in contract cases. We've been saying for years, the business people should come to the mediation because the business people should see that this case has weaknesses because their counsel has a success bias. Their counsel is telling them about how great their case is. The mediator isn't going to tell them they have a bad case, but I am going to ask questions that will make both sides think like maybe my case isn't quite as good as I thought it was. And that allows the business people to get a look inside the room and figure out, the real benefits of settling this and to do a better economic analysis. So that's another benefit of mediation. We hear that all the time, that, mediation was sort of that close to being tipped over as being a preferred part of a dispute resolution system within entities. But, it was an extra step, it was expensive, the business people didn't want to go. But with virtualization, they can pop in for 2 hours, learn a lot, and pop back out. So I think that has virtualization has really helped with that. The other thing is, I think as we start to become more sophisticated about dispute resolution, you may find that you have a case with another side that it's a big case. It isn't because you're an SME that your cases are going to be small. Often they're huge because you have a particular piece of technology or a pharmaceutical idea or whatever that's extremely valuable, but that's your company right there. So you might find that you go to mediation and you don't settle the whole case. So then what do? Do you just all go home and bring a lawsuit or an arbitration? My advice is not. My advice is to ask me or your other mediator, hey, could you please stay in place in parallel if the other side has to agree. So that's another thing to remember. Mediation, arbitration, all these things are only an option if the other side agrees. You can bring a lawsuit anytime you want, but you can't bring an arbitration or mediation anytime you want. The other side has to be willing. And that's why, for example, non-practicing entities, we call NPEs, who own patents, but own them just to sue people, you almost never see mediations with them because all they want to do is milk the patent to get their money. And so they have no interest in settling these cases. They have every interest in just kajing. And, so unless I think there's some special reason this case is worth mediation, it's almost never. These are people practicing their patents. So what I was trying to say is that, even if you don't settle the whole case, you can narrow it down. You can say, listen, we're agreed on all this stuff, but we've got this one issue that we can't agree to. How can we deal with that issue? And what we're learning is that there are different ways to deal with that issue. Organizations have put formal processes in place to allow you to just get an expert opinion on that one issue, very inexpensive. WIPO has one, the Stockholm Chamber has a new one. So you say, listen, this issue is remaining. Tell me what your expert opinion is. Or you can have an arbitration just over that one issue. It can be very quick. And you have the arbitration over that one issue that's remaining, or 2 issues that you saved a lot of time and money in the meantime. Now, my own view is that arbitration should be with a totally different person. Now, some people believe in what they call the Germanic model, where then the mediator becomes an arbitrator, or the arbitrator becomes a mediator. I'm not big on that. There are a lot of very talented people out there that Chiara can introduce you to be your arbitrator. It does not need to be me. And in my case, it probably won't be me, because there's almost never a case that I would be willing to stay on in a decision-making role after I've acted as a mediator. But then you get to the end of the case and you need to draft a settlement agreement. And that's one thing people have to remember. If you mediate a case, what you get at the end is a settlement agreement. It's another contract. So you still have to enforce that if the other party doesn't agree to pay or do whatever they're supposed to do. Now, settlement agreements are more likely to be enforced than other agreements, but not always. And there is a new convention called the Singapore Convention that does allow the enforcement of mediated settlements if there is a problem with the other side paying or whatever they're supposed to do. That is not enforced in many countries yet, though. So there are other ways to make sure that your settlement agreement at the end of a mediation is enforceable. For example, turning it into an arbitration award if you've thought about that in advance, because you can't just turn it into an arbitration at the end. To take advantage of the New York Convention, you have to have an arbitration extant at the time the mediation starts. This is all very complicated probably, but there's tricks to all that. But I guess my advice would be is, as an SME, to think systematically about how to avoid disputes in the first place. Have the right people in the room. Don't be too cheap on your lawyers, because at the end of the day, if you get yourself in a muddle that's going to cost you a lot more money or lose a lot more of your value, particularly if you get your value from intellectual property, than the lawyer's cost. And then, you know, once think about what you're going to put in, if you do get in, you know, then think about what kind of contract clauses you want in your agreements. I always tell my clients to put in a mediation followed by short form arbitration. But I do tweak the WIPO clause, because the WIPO clause has the mediation end at the end, you know, and then the arbitration begin. My own view is they should continue in parallel. And I think the WIPO is thinking about amending their clause in that respect. So long story short, mediation is facilitated settlement. A good settlement, even a bad settlement, is always better than litigation or arbitration, in my experience, particularly for an SME. So, and if you do have any questions about any of this, I'm available anytime. Just, you know, give Chiara or myself a call and we'd be happy to help you.
Thank you, Mrs. Paisley. Indeed, you have also registered to our SME2B platform, I hope. And in case the people can write you a message and ask you maybe to go more in depth of these questions. But before we come to the questions of the audience, I would like to ask Mr. Emmerich, you are also working as a mediator, no? Sometimes. Would you like to add something on these experiences and points that Mrs. Paisley made?
Especially one point I found very interesting, as Mrs. Paisley explained about the virtualization. I know that in the past, before the pandemic situation, there were always mediation by phone calls. It's kind of normal in some cases. But I think now this virtualization is very interesting, especially for small enterprises, because cost is always a huge problem. And it's one problem if you travel to France from Germany, for example, but if you have to travel if the parties are from different continents, for a small enterprise, this could be a huge problem. So I think this point that virtualization facilitates mediation is very interesting. And I thought about when she explained it, I thought about putting it even in the arbitration clause, for example, to incentivize small enterprises that say, okay, I agree to mediation or arbitration proceedings, for example, as a licensee in a licensing contract, but I'm kind of afraid as a small enterprise about cost of traveling, or would it be possible to beforehand decide that all the mediation process is online? So I think this will become even more interesting for small enterprises to facilitate the mediation. I think it's a very, very, very interesting point.
You know, I put it in my clauses. I don't make it mandatory, but I do put it in my clauses, you know, says, you know, the seat of the mediation or an arbitration shall be X. And then I say, you know, however, there's the presumption is that the proceedings will take place virtually. And that way, if something, unless the mediator or arbitrator decides differently, because there may be a case that you don't anticipate going forward where it really does make sense to sit around the table, and I don't want to tie my mediator's hands, but that I put it in as a presumption that they will be virtual for just that reason. And also just,
exactly.
You know, having just gotten off a plane from New York to Heathrow, there's real pluses to virtualization, let me say.
Yeah, I know it's even complicated within one territory, within Germany to get to a court proceedings in another state, and exactly as you explained, you always have to see when goes the plane. So I really think that virtualization is more comfortable for all the parties, and they feel more comfortable maybe in their office negotiating or settling a case. So very interesting point. I think
I see that. I see your point, Mr. Emmerich, but I must also say that also from our experience as a confederation of SMEs, and of course we have many meetings also on policy issues and lobbying questions and so on and so forth. I think that we need a little bit more time of experience on these digital meetings like this one, or if you then apply to a mediation or arbitration, that I think reliability, commitment, trust is easier to be built when you meet in person, because there's these small rituals of saying good morning, and maybe in the middle of something that you don't act really on the point, but you see already the people. I don't know. Maybe we need a little bit more experience. But anyway, if it's not mandatory, it's good. You can try in the first round if it works. Otherwise, then the best thing is to meet, I think. But let us go back to the audience now. Finally, we have still 15 minutes for question and answers. Who would like to ask our speakers, Mrs. Acornero of the World Intellectual Property Organization of the United Nations, or also Mrs. Paisley and Mr. Emmerich, something regarding the arbitration alternative dispute resolution methods and services that they offer? Mr. Atta, your connection to the microphone does not work. Can you please write the question in the chat? You have tried several times to raise your hand. Maybe you have a point that you would like to make. Who was there that was opening the microphone? Please simply take the microphone and start to speak. Hello? Okay, here's another connection. Coming.
I think Mr. Atta's on now.
No, his microphone, he does not work the mchirophone. Most probably he has blocked the use of the microphone before. Somebody's
I can ask Chiara a question.
Chiara, are you there?
Absolutely, I'm there. I think my video is fading off. There is sun in Switzerland, which is an exceptional. Okay, maybe now it works better.
Yeah.
An exceptional situation. Please, Kathleen, go ahead.
So, are you starting to see more parallel mediations? So, the mediation continuing in parallel to an arbitration?
Certainly, and I was hesitating to mention that during my presentation, but very often in some cases, what happens is that right away in the mediation phase, the parties do not find a settlement there, or only maybe a partial settlement. So, and that's already great because there were 5 issues at stake. They managed to resolve 2, so they only have 3 left. They start, say, the arbitration. And then during the arbitration, also maybe seeing that the arbitration is taking longer, is costing a bit more, they actually do realize that there was some space for settling also the other matters. So sometimes what they do then, they suspend the arbitration, they keep meeting, they start negotiating themselves, and they manage to find a settlement. And you know, this is actually more frequent than you would think, because we see that even in arbitration, the parties settle, so they find this solution in 30% of our cases. So that's quite a lot for arbitration. So I think for us, the takeaway is that it's never too late to mediate, even when you're involved in a court proceeding, in an arbitration proceeding, you're never too late to go back at the negotiation, at the mediation table and find a settlement.
Thank you. I see we have a question from someone. Yeah, there's a question.
We have here a question of a participant called Interior Project. I don't know if it's a woman or a man, but she or he asks us, don't you think that the arbitration should be in the country, so should take place in the country of origin of the IPR rights? So that means to oblige the breacher or the supposed breacher of the rights to travel and come to the country. What would you say, Mrs. Paisley?
Well, I think it really, as a good lawyer, I will say it depends. So if there are benefits, I mean, as we talked about earlier, the New York Convention allows for the enforceability of arbitral awards issued in other countries. However, where there's a national right at stake, so if there's really an arbitration over a single national patent in a particular country, and you want to ensure enforceability, I might have a preference for having the seat in that country, because then you get over one step of enforceability. In other cases, there are other countries where it's easier to enforce actually international awards than it is to enforce local awards. So you really have to look at the facts of that particular jurisdiction. You know, however, at least in my experience, most of the cases that we see involve multiple patents from many jurisdictions, or at least a patent which has been nationalized in many countries. So, you know, the days where you had one patent in a particular country, you know, I think are becoming slimmer and slimmer, fewer and fewer, but I take the point. And, you know, that is, you know, the real benefit of both mediation and arbitration for intellectual property rights, provided you're sure that the jurisdiction allows for the arbitration of intellectual property rights, which is a whole nother subject, but almost always they do now, relates to their national nature. You know, it is very expensive to litigate these patents all over the world. If you can reach a mediated settlement or an arbitration where you, for example, agree that you're going to look at a bucket of patents and then have that decision apply across the board, you can do all kinds of creative things that you can't do if you're in a court proceeding. The other thing I think that, you know, people always tell me, but Kathleen, I want to have an award that's enforceable against, you know, third parties. And other than in Switzerland and Belgium, that is not the case with arbitral awards about intellectual property rights. Or there may be a couple, but very rarely. But then, you know, the question is, do you really? Because then you bet the whole shop on one court proceeding or two court proceedings. Whereas if you do an arbitration, one of the blessings could be in many cases that it's only binding between the parties and your right remains extant for others. So I think it's the thing about intellectual property, which makes it so interesting, is that it has all this overlay, you know, and many of this is done in the context of a license agreement, right? So you've got a contract, but then the question is what's covered and what, you know, I think it's very interesting because it requires you to really understand the national laws that apply to each of the patents and where they can be arbitrated, et cetera, et cetera. So it's a great question. Thank you.
Wow. Mr. Atta, your microphone is working now, finally. Do you want you to ask a question? Mr. Atta, Peter, can you hear us? Okay. A lot of background sound. Mr. Atta, can you hear us? No.
It's too bad because he clearly has a question. You should, Mr. Atta, you should type it in the chat.
Okay.
David, why are you in Brazil at the moment? What brings you to Brazil?
Maybe somebody would like to add. Yeah, Mr. Emmerich. Yeah, sorry.
No, just I'm trying to get a cross-border group with a Brazilian law firm specialized in intellectual property. So in order to offer let's say a service regarding intellectual property with law firms situated in Europe or in Germany and in Brazil at the same time. So this kind of would be kind of interesting project, which is only in the beginning. So
Cool.
things take some time, but will be interesting.
Yeah, maybe you would like to add something to the answer that Mrs. Paisley gave, Mrs. Acornero, maybe regarding the country of where the arbitration should take place?
Well, that really, again, I would answer the same, really depends what your objectives are. Also, there are different laws which apply, so you may want to have a look at that. But certainly you may want to choose a place which is, for example, favorable of arbitration, which also sort of facilitates the enforcement. So that's definitely something to keep in mind. Also, it could be the place where you want your right to be enforced. That's definitely something that it really depends on the situation, on your objective. They will suggest the best person to speak with is your lawyer, because that could really advise you best.
Maybe as a sociologist, I would like to add, let's say, the communicational point of view. Of course, let's say there are legal considerations because of a legal jurisdiction, like a national jurisdiction that favors or makes the situation worse or better. But the communication point of view, the relationship point of view, makes it maybe challenging if you insist on that, and that Muhammad has to come to the mountain, that Henry has to come to Canossa to say sorry. So that is really, it's first a gesture of you understand what I mean. And that makes it maybe a little bit challenging. If you really want to get through your interests, you might consider not to insist on certain conditions too long. I mean, it's my personal view. Of course, I'm not a lawyer. Mr. Atta, do we want to try it again, or nothing to do? He left the meeting, I see. Okay, so Mrs. Eva, your microphone is open since a while. Do you want to ask something? Hello? So, okay, I see there is no other questions.
No, Lydia had a question.
Yeah.
About whether it would be better to enter. I think this has to be for Mr. Emmerich, Dr. Emmerich, because what is better to enter the Latin American market, via the US patent or an European patent? I'm interested in that.
First of all, I have to make clear, I'm not an expert on Latin American intellectual property law yet, but this would be a question for a Latin American, Brazilian lawyer, of course. But from my point of view, I can't see why there would be a difference, because in both cases you already have a patent in one state that is party to international patent treaties. So you could use this patent as a basis and enter the Brazilian market. I don't think there's a difference if it is a European patent or a US patent.
In pharma, they would want you to have both, and particularly a US patent, and then they'd want you to have selected big jurisdictions in Latin America as well. So they'd want you to have a couple big jurisdictions in Latin America. But if you had to choose one, I think it's probably the US. But I hope, it's definitely something to talk about with your patent attorney and strategize with. And the WIPO, obviously, one thing you'd want to think about is, starting off with the WIPO patent and then application, and then go forward from there. So you keep your priority date as early as possible. But this is stuff that, it's very specific to what your product is and what you're trying to achieve. So, but it's a great question and something, people don't think early enough about, but the WIPO process can play a very important role in that.
Yes, and I see also another question that is here from Mrs. Amel Thala. Would you please ask your question?
Hello, good morning. Okay, my question is not directly related to the team. My question goes to Mr. David Emrich. According to the presentation, we're talking about the difficulty people are facing where they are managing international registration. In fact, I applied for an international registration, and up to now, the period where I was supposed to have a feedback from the design office is already finished. So there is no feedback from the design office. There is no feedback from WIPO, because they say that when you apply, if the design country didn't reply, WIPO will probably send you any document or information that can prove that you have already registered. So my question is to know how to manage it in that case, please. Thank you.
I'm not quite sure if I understand correctly. So you applied for an international registration with your design with via WIPO, right?
Yes.
Yes, and now you have some problems getting information from the national design intellectual property office. Is that correct?
Yes.
So yeah, actually, my point of view, the process of international registration is always via WIPO. You should ask there why you didn't get any information back from your registration. Or
I think
yes, I would like to know, because the period of 36 months is already passed. So my question is how we as applicant can manage it, because I cannot go to WIPO to ask the question. I cannot go to Ghana to ask the question, because I myself am from Cameroon. So I would like to know how to manage it, please.
you're trying to get a design registered in Ghana.
Yes, but I'm from
okay.
Cameroon, and I did an international application, and the 36 months are already passed.
And you didn't have any response from the Ghanaian?
No.
Okay. Well, this is a very particular question. I don't know if Ms. Acornero has any information or any additional help.
No, not really. But there is a customer service, a WIPO, which then forwards all related communication. For example, this is a patent one to the patent team responsible for PCT applications. So you may also want to get in touch with them. That's also an option.
Okay, thank you.
maybe
also, did you try to get? Excuse me.
Maybe also in Ghana, there is directly the Secretariat of the African Continental Free Trade Agreement, which is, of course, linked also to the free circulation of goods and services. That means also protection of intellectual property rights. You might ask them also to contact the national authority in Ghana to give you an answer, simply.
Okay.
Yeah, one. I think maybe I don't know if you have any access to a lawyer in Ghana, but maybe a local lawyer could help you better to maybe he is more familiar with the proceeding, with the local proceedings, with the intellectual property office in Ghana, and maybe he knows exactly what to do, whom to contact in order to accelerate the process. I don't know if this would maybe an option.
Okay, thank you very much.
Well, thanks to you, to your question, and to your interest, and that is also directed to all the participants which stayed with us until this moment. I would like to thank in particular very much the World Intellectual Property Organization and Mrs. Chiara Acornero that offered us this insight into their services and support for SMEs worldwide to defend their intellectual property, saving as much as possible money or increasing as much as possible the value of their intellectual property, thanks to alternative dispute resolution with arbitration and mediation. And also, of course, very great thanks also to Mrs. Paisley for her very interesting insights, and to Mr. Emmerich for making clear what is the level playing field, which rules and procedures are on the ground, and why at the end mediation or arbitration procedure would be most probably favorable for your interests. I would like to repeat that the whole webinar has been recorded. We will now put that on our website and send to all participants and registered participants this recording, an email where they can find the recording. And I would also invite you to use the SME-to-be trade and international networking platform that we have, that we are offering to SMEs all over the world, to get in contact with other participants and other companies out there, in case you would like to develop your business, distribute your products, or source them from other sources where you would like to have a partner. Thank you very much to everybody, to my colleague Lorenzo Marchese and my colleague Giorgia Morossi that helped us to organize this event. And I would wish you all a good end of the week and a nice weekend.
Thank you. Thanks for having us.
Thank you very much.
Good luck with
for having
everything.
us. It was a great pleasure.
Pleasure.
Bye.